Hi, everybody. We're back in the law shanty. So we posted the last one of these on the 5th of January, and then the 6th came, and everything changed. So we're not going to talk about COVID today. There's not really anything new going on the COVID front anyway. As you know, the vaccines are continuing, and but there's no new law that we need to worry about this week other than the face mask order, which is more broad than employment law. So we're going to talk about something different. What we're going to talk about today is firing people for things that they do or say or write on social media, and whether or not you can do that, what your rights are as a private employer. I'm going to do it in kind of a funny way. Okay, we're going to assume that one end of this spectrum is that you are a private employer with at-will employees. And we're going to start over here at the other end of the spectrum and go through some exceptions to the general at-will rule that'll walk us kind of to the end product, if you will. We're going to assume that what your employees did on social media was lawful, not a crime. And then we're going to kind of walk through this. All right. So we're going to start with if you're the government, if you are a government employer, federal government, state government, local government, doesn't matter. If you're the government. If you're the government, you are more restricted than a private employer, and your employees have more rights. They have more rights because of a little thing called the First Amendment to the United States Constitution. Here's what the First Amendment says for those of you that don't know. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. We're going to focus for a minute on the first 5 words of that amendment. Congress shall make no law. That applies to government action only. Our friends over here on the other end of the spectrum, private employers, when an employee comes to you and says, I have a First Amendment right to do or say whatever I want, the answer to that is yes, you do, but not with respect to me as a private employer. That applies to government action only. Now, if you're a public employer, it does apply to you. But even then, that right is not unlimited. Okay? It is not unlimited. We all know that you cannot walk into a crowded theater and yell fire. The government can make a law that says you can't do that because the public good outweighs your individual right in that particular case. So there are even limits there. Now, I'm not going to get into the limits for our clients that are public employers. If you have an issue, you should talk to your labor and employment lawyer, and you should walk through it with him. But understand that if you are a government employer, you have more limits on you than if you're a private employer. All right, exception number 2. You are a private employer who has employees who have a contract. Now, this can be either a union contract or an individual contract, but it is a contract that provides for just cause termination. Most union contracts do. I've seen a couple, believe it or not, in my 30 years of doing this that don't. Many individual contracts do, but not all. Usually with the individual contracts, we have a definition of what just cause means. Not necessarily in a union contract. They often just say that the employer promises to only fire for just cause. Okay. That means that what the employee had to do outside of work has to rise to the level of just cause in order for you to fire the employee for doing it. Okay? So that's exception number 2. Exception number 3. You have employees that work in a state that has a state law prohibiting you from firing the employees for off-duty conduct. Now, there are some of them. Michigan is not one, and we'll come back to that in a minute. But there are some, and I'm going to give you an example of one. And believe it or not, it's not California. although California has a law like this too. I'm going to give you Colorado's because Colorado's is very, very broad. Colorado has a statute that says it shall be a discriminatory or unfair employment practice for an employer to terminate the employment of any employee due to that employee's engaging in any lawful activity off the premises of the employer during non-working hours unless, and then there's a couple of exceptions. That's a pretty broad statute. Now, we don't have that in Michigan, but that's a pretty broad statute. So if you have employees in other states, salespeople, other plants, things like that, before you go fire an employee for something they do off duty, you've got to check that state's laws. And there are a number of states that have them. Now, we don't have a statute like that in Michigan, but we do have a very little known provision in Bullard-Plewicki, and you all know what Bullard-Plewicki is, right? It's the personnel file law that actually prohibits you from gathering or keeping a record of employees' off-duty associations, political activities, publications, or communications of non-employment activities. So you can't keep a record of that. It doesn't say you can't fire employees for doing something off-duty. It says you can't keep a record of those things. If you have a question about that, give us a call and we can walk through it. Believe it or not, that statute, there's not a lot of litigation on that part of the statute or Bullard-Plewicki generally. So we don't have a lot of definition from the courts, but we do have that part of statute. And you can give us a call and we can talk you through that if you need to. Okay, fourth exception. You can't have a policy or fire people in a manner that's discriminatory under one of the other statutes. Our good friends Elliott and Larson and our buddy Title VII of the Civil Rights Act of 1964 jump quickly to mind. So I cannot say I'm going to have an employee because I'm an old man. I'm going to have an employee, a policy that says I'm an old man, but I don't like having old people around me. I like having young people around me. So I'm going to have a policy that says any old person who publishes anything on the Facebook that I don't like, I'm going to fire. But any young person who publishes anything on, I don't know, Space Monkey or whatever kids are using these days, I won't fire them, right? So we've got our list of protected characteristics. We know what they are. And we can't have a policy that discriminates against somebody because of their membership in a protected characteristic. Okay, number 5. And this is a big one that most people don't know about, but this is really a big one because this is the group, the NLRB is the group that over the last 20 years or so has spent the most time focusing on social media prohibitions. And that is Section 7 of the National Labor Relations Act. What am I talking about here? Palazzolo, I don't have a union. Section 7 of the National Labor Relations Act does not apply to me. Yes, it does. Section 7 of the National Labor Relations Act says the following. Employees shall have the right to self-organization, to form, join, and assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining and other mutual aid and protection. Section 7 of the National Labor Relations Act applies to all employees as that term is defined in the National Labor Relations Act. Doesn't include supervisors, quote unquote, as those are defined. Doesn't include HR people. Sorry, HR people, you're not protected by the NLRA. Other than that, it's all employees. All right, that's a broad definition, and it doesn't just apply to employees who have decided to certify a union. It applies to all employees. So, what does it protect? It protects protected concerted activity. The activity has to be concerted, a group of people, or one person acting on behalf of other people, and it has to be for over terms and conditions of employment. Okay? If I'm complaining about the weather on Facebook, I'm not engaged in terms and conditions of employment, right? I'm not talking about terms and conditions of employment. But if I'm complaining about my supervisor, I am talking about terms and conditions of employment. And the board has broadly defined those terms. And they will again under the new administration. I don't know if you recall under the last administration, the board was moving rapidly into getting its fingers in things like handbooks and stuff like that. And I think we'll probably see that again going forward. So you can't fire an employee who's engaged in protected concerted activity. All right? So what's that leave us? Now you're just a regular old, plain old, at-will employer with at-will employees in the private sector. And somebody goes on Facebook, somebody goes on YouTube, somebody goes on something, and they do or say something you don't like. Can I fire them? Yep, As long as it doesn't fit into one of these exceptions, you probably can. Now, I say probably because I'm a lawyer. And we always say probably. We don't work in definitives because facts matter, right? Facts matter. So we need to look at these things individually and decide if we can fire the employee and what the consequences of doing that will be. Now, I'm going to end with one more thing, okay? The presumption underlying all of this has been that what the employee did was lawful. The First Amendment says peaceably assemble. The Colorado statute says lawful activity. The NLRB requires that the activity be protected concerted activity over terms and conditions of employment. Lawful activity. If you have an employee who is stupid enough to film themselves or be filmed committing a crime, give me a call, but we're not talking about this now. We're talking about employees engaged in lawful activities, not committing a crime. And I would take the position that an employee that's stupid enough to be filmed committing a crime is too stupid to work for you. I will see you next time.